Our guest today is attorney Eric Sloan of Chiumento Law. Eric has built his career working with healthcare providers, businesses, and professionals on compliance, litigation, and corporate matters. With deep experience in healthcare regulations, privacy, and dispute resolution, he brings a well-rounded perspective in legal challenges organizations face today. Eric, welcome.
Thanks, David.
Good to have you. So, would love for us to talk about, I know, an area that you spend much time in, and that is the area of litigation and dispute resolution related to healthcare. And so, we don't have to look far from, our television or whatever the case may be to know that healthcare is a big deal, and there are things that happen in healthcare that cause people to have to seek legal process. And so, I'd like to first ask you, what is so different about healthcare lawsuits, litigation, disputes versus other industries?
Two things. I think lawsuits against physicians, first of all, we assume that a physician has a lot of money, right? They drive a fancy car, they have a big house, they've got a doctor, they've got a fancy piece of paper. There must be a lot of money there. Second thing is the insurance. Doctors and mid-levels, they pay a lot for malpractice. That makes the profession, the industry, a natural target because they know that these people do have two nickels to rub together, and let's go after it.
Okay. And so the would-be defendant or that's going to be sued has money, or people think they do, and they've got insurance. What I thought you're going to add is also that they are held, and this may also be the case, held to a high standard. Like, look, I'm going in for this type of surgery. I'm expecting to have a perfect 100% result. And so when you expect 100, you don't always get it.
True. And I don't know if it's the top cause of death in America, but it's within the top 3, top 5, and that's medical negligence. But I think that our society as a whole, we're getting a little too litigious. So everything's a lawsuit, everything is unfair. But the reality is that we're all human. We can all make mistakes. And if something bad happened, but there wasn't negligence, this was all done within the standard of care. Really, there is no case. But I think my point was you can still try to make one just based on the assumption that there's a lot of insurance, they're going to want this thing to go away, or there's a lot of money if the insurance isn't, high enough.
Yeah, I know that's sometimes referred to as a frivolous lawsuit, or maybe there's other terminology, but and that, of course, presses up the cost of insurance. It's ultimately passed on to the consumer.
100%. I
mean, the consumer pays for everything eventually. So in these situations, from your experience, instead of specifically saying, well, this is automatically going to court and there's going to be, a hearing and there's going to be the whole thing, do you often find that there is, resolutions that can occur with mediation or arbitration that help to, facilitate a reasonable and appropriate resolution of it for the consumer, patient, and the doctor or the provider?
There are, and we hear often about tort reform, this phrase tort reform that pops up every once in a while. It does have a broad application, but down to the nuts and bolts, it's really about medical malpractice reform than anything. So there are pre-suit steps that need to take place. I think the problem with it, and in theory that's good, but I think the problem is that if we do have an insurance policy involved, and we probably do 100% of the time or close to it,
right.
It's just like if we were in a car accident, all right? We turn in the claim, or maybe we caused the accident, we lose control, right? Our claim, our reputation is now with an adjuster in a cubicle somewhere, making important decisions on how you're going to be viewed. So anything pre-suit that can stop litigation, 100% in favor of. The litigation process, and especially in the state of Florida, our dockets are very crowded.
Well, I would think that I think the key word is losing control. Once it goes down that path, then it becomes it's a purely financial decision for the insurance company, and they're doing risk analysis, and that's what these actuaries and their risk specialists do.
Yep.
So Eric, can you give us an example of where you saw mediation or arbitration or some sort of early resolution before we get to actual lawsuit help to resolve a healthcare related matter, not just with medical malpractice or something like that, but with also more generally in the healthcare area?
Right. Well, if we can just step back out of malpractice, because those are tougher ones,
Right.
and there's a lot of different factors that go into those. Just general litigation that involves health practices,
Okay.
and where it usually hits my world, you have a group practice, and the partners start fighting with each other, and now the business is suffering because they don't get along. If you can mediate that to an early resolution, way better.
Okay, that's good. So how about in the overall healthcare, litigation area? What are some of the trends you're seeing? What are some things that are evolving, in light of technology and insurance practices and the way healthcare is dispensed? What's evolving and changing that would be helpful for people to be aware of?
Oh, I think, are we still in the litigation context or,
Sure.
or the litigation context? Everything to me in my mind is pre-COVID and post-COVID.
Really?
Yeah, I still have cases of my own from 2020 that I'm still trying to work through the system that we just can't get a trial date set for one reason or another.
Wow.
I tell clients that don't expect this to be an episode of Law and Order. It will not be done in an hour. General track for us right now is 18 months from the date of filing the complaint to when we're supposed to be ready. That's a long time. And our dockets are too full. So going back to what we discussed before, anything prior to litigation to resolve it, and really, if you do mediation, it's the last time that you get to control the outcome. If litigation puts that decision in a third party's hands, a judge or a jury, they may like you and you'll do well. They may like you and hate your lawyer. And juries do make decisions.
That never happens, right?
No, I mean, of course not. Of course not.
What is it about, pre and post COVID? What is it? Just pure backlog? I mean, is that what we're talking about? The number of cases that could not be pursued during that time period of everything being shut down?
The legal profession really changed during that period. So now we do a lot of Zoom. It's rare for us to go to court on a motion. It's usually a Zoom. Depositions are typically Zoom. So we do a lot of it informally. But yeah, once there was a shutdown,
Right.
And all of that shut down as well, those cases had nowhere to go. And then by the time we went back online, well, now we have a lot of stuff that is new. And it gets, some of that goes faster, some of the other stuff. But the longer you get away from it, witnesses disappear. People can't, recollect what happened, and they become harder to litigate.
Right.
So I'm 100% in favor of early resolution.
Okay, mediation is definitely something to consider. Very good. Eric Sloan, thanks for being with us.
Thank you.